times, the end result of the probate process is that ownership of the real property that was in the probate estate is transferred directly into the names of the beneficiaries. As heirs, this can leave you co-owning real property with your siblings, cousins, even a step-parent. So what happens when these new owners don't agree on what to do with the real property? Maybe someone wants to sell it, another of the owners wants to rent it out as an investment, and even another wants to keep it and maybe live in it themselves. Well, in Florida, if you co-own real property with someone and no longer wish to co-own real property with that person, and no agreement can be reached between you, any of the co-owners can file a partition suit in circuit court to end that co-ownership. So when we're dealing with large, usually vacant parcels of multiple acres, a partition action does exactly what it sounds like it does. It divides the large parcel into multiple smaller parcels, and so each owner gets their own smaller piece that they own alone, and they no longer co-own with someone else. However, when we're talking about a single family home on a platted lot, you can't really slice up a house. So the judge in the partition case will order that the property be sold and that the proceeds from the sale be divided among the owners based on their percentage of ownership. Unfortunately, as with any civil lawsuit, a partition action can be time-consuming and quite expensive. And under Florida statute, the attorney's fees are technically shared by all of the owners, regardless of who hires the attorneys. So partitions can be done for any reason and in any situation where two or more people own property together. But I would say in all of the partitions that I have been involved with, they've been for one of two reasons. The first, unmarried couples who own property together and then break up. And equally, if maybe not even more so, siblings and other relatives who inherit property and either they don't get along or they just can't agree on what to do with the property. So when you're thinking about your own estate planning, there are ways to plan ahead that can help avoid putting your heirs in a situation where a partition suit might be necessary. And this can be done in conjunction of ensuring that they can avoid the probate process altogether. And so if you have real property in your state and multiple heirs or beneficiaries, we would be happy to speak to you about all of the options available to protect your assets and to protect your beneficiaries.